Today I'm going to cover a topic about data protection impact assessment uh, and how it's applicable to our day-to-day organizational activities. So, DPIA, so Data Protectional Impact Assessment, a strategic framework for privacy risk management. So, in an increasingly data driven world, organizations collect, process, and analyze vast amounts of personal information to deliver their services, optimize operations, and innovate. However, this reliance on personal data brings significant responsibilities. Chief among them, the obligation to protect individuals' privacy and compliance with data protection laws. So, the GDPR enforces across the European Union and influencing global privacy standards mandates a powerful tool to help the organizations meet these obligations. So, the data protection impact assessment helps us meet the obligations of GDPR. So, data protection impact assessment is not a legal requirement. It's a strategic process that enables organizations to identify, assess, and mitigate privacy risks before launching new data processing activities. This article explores the reason for conducting data protection impact assessments, its objectives, expected outcomes, the requirements, and the 5 key stages of the data protection impact assessment. First, we look into why we conducted data protection impact assessment. What are the reasons? Under Article 35 of GDPR, data protection impact assessment is required when data processing is likely to result in a high risk to the rights and freedoms of natural persons. But beyond regulatory compliance, there are several compelling reasons to conduct a data protection impact assessment. The first one being risk prevention. So, data protection impact assessments help organizations to identify the potential privacy risks early in the project lifecycle by anticipating threats such as unauthorized access, data breaches, or discriminatory profiling. Organizations can implement safeguards before harm occurs. The reason for conducting data protection impact assessment is legal and compliance. So, conducting a impact assessment demonstrate adherence to GDPR requirements, particularly the principles of accountability, transparency, and privacy by design. It also supports compliance with other data protection laws such as Digital Personal Data Protection Act (DPDA) or the California Consumer Privacy Act. Similar to these. The third reason for conducting a data protection impact assessment is trust and transparency. When an organization performs a data protection impact assessment, it shows the customers and stakeholders, the employees, and also the regulators that the organization takes privacy seriously. Uh, they build trust and enhance the organization's reputation. The next one would be the operational efficiency. By integrating privacy consideration into the system design, the data protection impact assessments can reduce costly redesigns and avoid delays and streamline compliance efforts. The next one reason for having a data protection impact assessment is strategic decision making. So the data protection impact assessment provides a structural framework for evaluating the impact of new technologies or business models, helping leaders to make informed ethical decisions. Okay, let's move on to what is the objective of the data protection impact assessment. What do we achieve by performing a data protection impact assessment? The primary goal of having a data protection impact assessment is to ensure that the data processing activities with respect to individuals' privacy rights are conducted in a lawful, fair, and a secure manner. Specific objectives include identifying and documenting processing activities, assessing the necessity and the proportionality of the processing, evaluating the potential risks to data subjects, designing and implementing mitigation measures to reduce or eliminate risks, demonstrating accountability to the regulators and stakeholders, supporting privacy by design and default in system development. By achieving these objectives, the organization can embed their privacy into their culture, operations, and rather than treating it as an afterthought. Okay, what are the outcomes of data protection impact assessment? So the well executed data protection impact assessment gives us a list of risks. That is, we can have a detailed record of identified risks their likelihood and the severity and the potential impact on the data subjects. That is a risk register. The second one would be the mitigation plan. How do we mitigate these risks? So once we identified the risk, we can use a set of technical and organizational measures such as encryption, access controls, or staff training to address the identified risks. The third one would be documentation for compliance. So the evidence that the organization has considered privacy risks has taken appropriate steps which can be shared with the regulators if needed. Improved system design. If we have a data protection impact assessment in place, whenever there is a system modification required, we can consider the data protection impact assessment before modifying or implementing a new design. Stakeholder confidence. So it will increase the trust among customers, employees, and even the regulators that we are taking privacy seriously, that the organization is taking the privacy seriously. Okay. Consultation requirements. The next step of data protection impact assessment is consultation requirements. Consultation is a critical part of data protection impact assessment. It ensures that diverse perspectives are considered and that the assessment is thorough and balanced. So who do we consult? We consult internal stakeholders and external stakeholders. So who are internal stakeholders? The data protection officers must be involved in the data protection impact assessment process to provide expert guidance. IT and security teams offer insight into the technical risks and mitigation strategies. Legal and compliance teams ensure alignment with regulatory requirements. Business units provide context on the purpose and the scope of processing. External stakeholders. Who are the external stakeholders? Data subjects, that is, the organization may need to consult the individuals whose data is being processed, especially if the risks are significant. If the organization is taking a customer's or someone's data, their input may be important here. Uh, the next one would be supervisory authorities. If the residual risks remain high after mitigation, the organization must consult relevant data protection authority before proceeding. Consultation fosters transparency, improves decision making, and helps organization anticipate concerns that may arise later. Okay, let's move on to the next step. What are the 5 stages of data protection impact assessment? The first stage would be initiation and scoping. So once we define the first objective is we define the objective, sorry, we define the scope, context, and the stakeholders that are involved in the data protection impact assessment. So the activities are: we identify the project or processing activity, determine whether the data protection impact assessment is required based on risk criteria, define the boundaries and assessment, example data types, systems, jurisdictions, assemble a cross-functional team, including the data protection officer. So what this first step helps us, it gives us a clear understanding of what the data protection impact assessment will cover and who will contribute. The next step or a next stage of data protection impact assessment. So the description of processing. The objective is the document the nature, purpose, and the context of data processing. So what are we processing? The activities are: describe the types of personal data collected, identify the categories of data subjects, map the data flows, specify technologies used, clarify legal basis for processing. Example, consent, contract, legitimate interest. So what will be the outcome of performing the second stage? We get a detailed overview of the processing activity, forming the foundation of risk assessment. The next step would be the risk assessment. So the ideal the ideal part would start from here. So the main objective of identifying the impact assessment is to understand the risks that it gives us. So we identify and evaluate the risks to the data subjects' rights and freedoms, analyze potential impacts, assess the likelihood and the severity of each risk, consider vulnerabilities in the systems, process, or human behavior, pay special attention to the vulnerable groups, example children, elderly, and marginalized communities. What is the outcome of this? We create a risk register that prioritizes threats and informs mitigation planning. The next step would obviously be mitigation. How do we mitigate this? The mitigations and safeguards. We design and implement measures to reduce or eliminate the identified risks. So the risks that were identified by performing this DPA, we would mitigate this. How do we mitigate this? We propose technical controls such as encryption and pseudonymization, recommend organizational measures, example policies, training, audits, evaluate effectiveness of each safeguard, ensure that the data subjects' rights are supported. Then the next one would be review and documentation. This is where we finalize the data protection impact assessment. We document the findings and plan for the ongoing monitoring. So we review the data protection impact assessment with the stakeholders, including the data protection officers. We document the decisions, rationale, and the residual risks. We determine whether the consultation with the supervisory authorities is required. Establish a plan for periodic review and updates. Here, the outcome is the data protection impact assessment report that demonstrate accountability and supports continuous improvement. So, what is the conclusion for data protection impact assessment as a strategic asset? In a world where data is both a resource and a risk, the data protection impact assessment is a vital tool responsible for data governance. It enables organizations to anticipate privacy risks, design effective safeguards, and build trust with stakeholders. Far from being bureaucratic hurdle, the data protection impact assessment is a strategic asset that uh, that aligns legal compliance and ethical innovation. Thanks everyone. That's all from me.